Hello and good afternoon to all of you if you're tuning in from the Eastern time zone, and to all of you elsewhere in cyberspace, good day. We're really glad to have you with us. It is the 23rd of January. Tough to believe that we are so far past New Year's that probably you can't say Happy New Year anymore. Though, if you haven't seen a good friend or a loved one, certainly I think it still applies. We have a full program for you. A lot has happened since I was last here as your host. Um, in particular, what I'll be addressing to start things, if Kathy, you could go to the next slide, I'll walk the group through the agenda. Thank you, Kathy. I will be covering the executive budget proposal that Governor Hochul introduced, and that is already the subject of vigorous debate, and we want to give you some sense of what's in that proposed budget. I won't have the final word by any stretch on it, but I'll give you some highlights, particularly around health and human services today. Kate Hajar is also with us, and Kate is not only my neighbor, whose wall is directly behind me here in New York City, but also someone who has presented here on the program a number of times previously. We're glad to have Kate back. Kate is going to build on the presentation a couple weeks ago from Seth Gilbertson out of our Buffalo office. At that point, it was back on the 9th, I believe, we were discussing higher education and what's ahead. We're going to go back to that subject because there's plenty more to cover. And so we thank Kate in advance for that. Frank Mayer will be with us from Albany. And Frank has also been on the program numerous times previously. Frank will be addressing employee retention tax credits. This is a complicated pandemic relating program that has seen a lot of scrutiny. There are new opportunities essentially to wind things back if there are issues relative to previously filed claims and amounts. Frank will go through all the particulars of that. It's a program that we know has touched many of you and your businesses, so it'll be worth a listen. Following that, Allison Roach will be with us from Buffalo. Allison is back on the program, and Allison will be addressing borrower defense claims in the student loan space. Plenty going on there as well. I won't steal Allison's thunder, though. I'll let Allison tell you more. I will be back to wrap things up and, of course, ensure that we answer your questions to the best of our ability. And with that, let me begin the presentation that I want to deliver to all of you on the budget as proposed. And so, as noted, Governor Hochul introduced her budget, which is an exercise in mid-January that happens every year, whether it's Governor Hochul, Governor Cuomo, Governor Patterson. This is the time that it happens in New York State. And so if we go to the next slide, Kathy, I can walk through some of the highlights that are affecting that proposal and that ultimately will be hashed out over the coming weeks through negotiations. One big thing to mention is that the Medicaid 1115 waiver amendment has been approved. We've referenced this in previous broadcasts many times over while we were waiting for this approval. And then ultimately, we now know that in New York State, there's agreement on the CMS side for about $7.5 billion to flow through. The math gets a little complicated in terms of how much is New York State's to provide versus how much is the federal government's. But the working number is $7.5 billion. And what is also important, because it relates to the budget that the governor proposed, a significant amount of that money is essentially counted on and programmed into this budget. And so the waiver will be focusing on health-related social needs, essentially, for those less familiar, care that's adjacent to more traditional healthcare, but in the vein of helping individuals stay healthy and well through community supports. There's also a significant amount of money for distressed downstate hospitals around here from where I'm broadcasting. And there are workforce pipeline initiatives that are baked in. There's a lot more if you get under the hood, as it were, with regard to the waiver. But the headline for the purposes of the budget is that there's a fair amount of money that the governor is counting on from that waiver that populates her proposal. And just as an aside, though, it's relevant for those of you in this space. and certainly the clients that the Health and Long-Term Care Group represents, of which, of course, I'm a participant. There's a lot of work around, well, how will this waiver, excuse me, ultimately get implemented? And there's an RFA that already has been issued. And that is just the beginning. There'll be more of that to come. Why don't we go to the next slide, please, Kathy? So a budget proposal always includes elements that someone is going to take issue with, that is more or less par for the course. This time around, talking specifically about health and human services, there are hundreds of millions of dollars in proposed cuts with effects on programming. And some of the deepest cuts are proposed within the long-term care continuum. And there are a number of reasons for that, which I'll get into in a moment. There are also cuts relating to reimbursement rates for certain capital projects. There's a look at the consumer-directed personal assistance program. And there's ultimately within the budget through the briefing book and attendant language, a call for organizations and other stakeholders touched by these proposed cuts to come together to essentially caucus and determine how best to find a savings target. So this is the beginning of what the governor is intending to be a negotiation, including stakeholders, the legislature certainly, but also others who are professionals in the space. So that's already beginning and more to come on that. Next slide, please. So getting back to that briefing book I was referencing, the governor indicates in broad form that there are indices that healthcare spending will be growing at a rate that the state cannot sustain. A lot of the monies that provided relative stability during the terrible times of the pandemic are winding down, and the governor is seeking to plan for that. And what others have begun to say in response is that as New York State's population ages, and that is objectively the case, the data suggests it's a trend that it will be continuing. It's part of why we have this master plan on aging that we've talked about before. It may not be, in the view of some, the right time to go forward with those cuts. There are others that are looking to see whether the Medicaid program specifically can be more robustly funded so that the services are connected to the reimbursement rates a little bit more closely, again, in the view of certain advocates. In the human services space, cost of living adjustments, as proposed by the governor, are fairly modest relative to last year's 5.4%. This year, we see a proposed 1.5%. And legislative hearings have already begun. They're happening today in Albany as we speak here. So why don't we go to the next slide, please, Kathy? One thing to mention as well with regard to the healthcare workforce, of course, we saw during the pandemic that various flexibilities in delivering healthcare proved to be invaluable, and ultimately New York State was involved in healthcare delivery modalities that prior to the pandemic had been generally not part of our practice. But one of the ways that the governor is proposing to essentially cement some of that is to enter into interstate compacts for licensed physicians, registered nurses, and LPNs. And so this is an ongoing discussion. There are, parties that feel this is a good idea, others that don't. We'll come back to this and discuss it further. But just note that would be a pretty big one if it were to ultimately make it into the final and agreed upon budget. There also is activity around assisted living in terms of quality standards and other aligned efforts to kind of bolster that space. If you turn to behavioral health with me for a moment, there's a provision to set a floor for commercial insurance rates on behavioral health services. As well, there's a requirement that's baked in that commercial insurance would pay at a minimum the reimbursement rate that Medicaid pays. And this is all tied, of course, to the governor's look at behavioral health, which began last year and which remains very much a priority for the governor. Next slide, please. And this is a biggie. I don't wish to steal the thunder, as it were, of Kristen Smith, who will be your host next week and is part of our labor and employment practice. Of course, though, all of you who tune into this webinar regularly ask, what's going on with COVID sick leave? There has been a sense generally across New York State that it has outstayed its value and welcome, particularly on the employer side, I should be clear. And what the governor has proposed is that, through the budget, essentially it would be wiped away. It wouldn't require a separate legislative act. That was something that was proposed in last year's session. It didn't go too far, as we've covered. And if this sticks, as it were, and there are reasons to believe it will, COVID sick leave will be a thing of the past come April or thereabouts. Next slide, please. And I should note, by the way, Kristen will be back with a far deeper dive on all things labor and employment concerning this budget. So stay tuned for that next week. In terms of what's next, there are going to be the one House bills, the 30-day amendments, all of the ebbs and flows that come with the budget negotiation process, and we're in that right now. We expect an agreed upon budget on or about April 1st. There are a few things that could affect that, including religious observances, Easter, Passover among them. We'll know more. The governor also demonstrated, particularly last year, a willingness to extend past April 1st to negotiate further on issues and elements that she thought were important to include in the final budget language. Our government and regulatory affairs practice, of which I'm a leader, will be monitoring all of this closely. And so please stay tuned. I'll personally be back to keep you all apprised, and others from the group certainly will be on the program over these coming weeks. Let me, with that, turn to our next speaker, who is Kate Hajar, as I noted, who's with us from the New York City office just behind me. And we're really glad to have Kate back on the program. Kate is steeped in higher education law, has experience both in-house, at the university level, as well as with Bond in 2 different stints. We are thrilled to be hearing from Kate around what it is that 24 has in store for us. We got some of the prognostication, as it were, from Seth Gilbertson earlier this month. We know there's a lot more to talk about. So Kate, please educate us. Let us know what we should be focusing on and what may be coming down the pike. Please go right ahead.
Gabe, thank you very much for that introduction and this invitation to return to speak with this group to continue the preview of just some of the issues that higher education institutions can expect in 2024. Next slide, please. So we fully expect that issues related to employee and student accommodations, disability-related accommodations, health accommodations will continue in 2024. In 2023, from the employee perspective, with the evolving nature of work from home policies, we can continue to see some misunderstandings persist among employees about the parameters of these work from home policies. And many have incorporated what were policies that grew out of the worst days of the COVID pandemic, have incorporated these now into years of their lives, and transitions back to in-person instruction, in-person work have been difficult, and we anticipate that as employers, as universities continue to try to bring more and more people back, that this will continue to be a struggle because frankly, COVID has not left us. It has taken maybe a new form, but it continues to be a concern among many groups of people with serious health conditions and other types of issues going on. So that will continue to be a struggle. From the student side of things, on this topic of accommodations, understanding reasonable accommodations, students' understanding of their responsibilities, as well as the college's understandings of their obligations under the ADA, Section 504, et cetera, will continue. We continue to see issues come up from our clients in this area. Institutions, of course, have an obligation to engage in cooperative dialogues or interactive processes with students who come forward with disabilities and the need for an accommodation of some sort. I think colleges have, more or less ingrained that understanding in their day-to-day operations. But, we still see some issues come up in that regard in terms of what a cooperative dialogue has to look like, the exchange of information and discussion between the students and the institution. Thinking about creativity in terms of solutions for reasonable accommodations is something that we continue to advise our clients to consider, thinking outside the box instead of relying on formulaic or check the box answers in response to certain types of accommodation requests. We have found that educating students as to their responsibilities in this space can be a helpful tool in terms of understanding that just because an accommodation is granted, that does not mean that the student is not obligated to continue to meet the educational requirements of the course or the educational requirements of the program. Oftentimes, we do see that as a misunderstanding among students. Good disability coordinators, disability offices at institutions will have those conversations early with students who present with disabilities, and those types of educational opportunities should continue with students throughout their time at the institution as disability needs and accommodation needs change over time. Seth did mention this in his presentation earlier this month, but it bears repeating and maybe expanding on here, which is to say that navigating speech issues on campus, we fully anticipate are going to continue to be front of mind for institutions in 2024. The balancing of First Amendment protections with the protections afforded by Title VI of the Civil Rights Act, as well as the New York State Human Rights Law, the New York City Human Rights Law. Those are difficult questions that institutions are going to have to grapple with, balancing pressures from outside entities in this area. By outside entities, I mean the media, donors, alumni, all of which have certain expectations and ideas about how institutions should be responding to world events, to local events, or events that are happening amongst their constituents on campus. Navigating those outside pressures can be very difficult for institutions. We continue to have conversations with our clients about how best to navigate those tricky waters. Educating students in particular about how to engage in discussions of difficult topics has been an approach that many institutions are taking, a return to that topic really that maybe has been put on the back burner in recent years, but really focusing on teaching students how to converse in respectful and civil ways is one approach that campuses are now taking to deal with some of the tensions that have grown on their campuses. We are seeing increased OCR. By OCR, I mean the Office for Civil Rights at the U.S. Department of Education. We have seen increased attention from OCR in terms of monitoring institutional responses to potential bias, discrimination, or harassment incidences on campus. And we have seen some recent Dear Colleague letters come from the Biden administration reminding institutions of their Title VI obligations to provide educational experiences and educational atmospheres and settings that are free from discrimination or harassment. So OCR has initiated many investigations on college campuses. We expect that will continue. They recently released a press release that is available on the OCR website, listing its current active investigations. So not only are these investigations occurring, institutions are going to have to deal with those investigations, but they are being made public, which adds another layer of attention on these issues. Okay, next slide, please. Gender equity in athletics is another topic that institutions should be paying attention to this year. Last year, we had some new guidance come again from the Office for Civil Rights in the form of what they call resources for colleges and universities. A version of this was also generated for K through 12 schools. And what these resources did is outline for really for students, written in a way that was directed at students or parents or interested parties, about what the institution's obligations were in terms of Title IX and the obligation to provide equal access to athletic opportunities for all students, regardless of sex. It really outlined in a detailed fashion, almost a checklist fashion, the requirements to provide equal funding for sports teams, equal or equitable, I should say, access to facilities, practice times, quality of coaching, etc. It's a very exhaustive resource, and for those colleges and universities who are listening today, I encourage you to check out those resources to become familiar with them, or just remind yourself of obligations in this space. And the links in this slide will take you to those resources. With the Title IX regulations that we're expecting in March of this year, we are also expecting some further guidance from OCR regarding transgender student athletes. And I will just end this portion of the session here, Gabe. I may be running out of time, is just to mention international programs and institutional affiliations. We anticipate that institutions will continue to pursue these relationships. And the challenges, of course, in this space will be to navigate the various compliance issues that are implicated in those relationships, whether they be labor related with faculty who are being sent over to international programs, or other student compliance or student conduct issues that may arise.
Hey, thank you very much. We know that this year 24 already has been complicated, and there are many intersecting issues that you have addressed in your presentation that we'll all be watching. Please come back onto the program as we get deeper into the calendar year in order to update this group. And again, thank you so much for taking this time. Let me turn now to Frank Mayer, who's an attorney with us from Albany, who has been on our program a number of times over, has deep experience in tax law that is very much relevant to the employee retention tax credit program, one that has been both an opportunity and a headache for a variety of employers. And Frank, I trust that you'll be updating this group about what's new and some of the scrutiny on the program. I know that in previous presentations, you have touched on this program, so I know the group will be interested in learning more. Please, Frank, go right ahead.
Well, thank you for that introduction, Gabe, and thank you to the group for attending today. So I'm going to run through a brief overview of the Employee Retention Tax Credit and the IRS's new voluntary disclosure program. So as most of us have seen or know, the Employee Retention Tax Credit is a refundable payroll tax credit available to certain employers that kept paying employees despite shutdowns imposed due to the COVID-19 pandemic, or that faced substantial declines in gross receipts during the period March 13th, 2020 through September 30th, 2021. Now, although those periods have long since passed employers still have an opportunity to claim the credit through at least April 15th, 2024 for the 2020 tax year, and through April 15th, 2025 for the 2021 tax year. Now, as some of you may recall, to qualify for the credit, an employer must satisfy one of the two eligibility factors. One, either the entity suffered a full or partial suspension of its operations during any calendar quarter due to a government-ordered shutdown, and it more than nominally affected the employer's business, or the entity experienced a significant decline in gross receipts during the calendar quarter. In 2020, that meant a 50% decline in gross receipts for the relative same calendar quarter in 2019. And in 2021, a less harsh or less restrictive 20% decline in gross receipts for the same measurement quarter in 2019. Now, on September 14th, 2023, moving ahead, the IRS announced an immediate moratorium on the processing of new employee retention credit claims. Excuse me, this is amid a surge of questionable claims. The moratorium ran through the end of 2023 and increased the processing time for a refund claim from about 90 days to 180 days. Now, we've all seen in the popular press the update in the self-proclaimed employee retention credit expert advertising. You can get $26,000 per employee, imply in minutes and have your refund in hours, and to use a little hyperbole, but basically saying that you could get this refund of $26,000 per employee, meaning that would be $5,000 in 2020 and $7,000 in each of the first 3 quarters of 21. Often these agreements that these preparers would provide for a fee structure based on a percentage of the employee retention credit, which the advisor calculated. The fee is often due before the credit was filed for or received, and is due even if the taxpayer decided not to go ahead and make the claim. So because of this, the IRS has issued numerous warnings and even added the employee retention credit scams to their so-called dirty dozen list of the most prevalent tax scams for 2023. Now, the news here about all of this is that on December 21st, 2023, the IRS launched a new voluntary disclosure program that allows businesses to pay back only a portion of the incorrectly calculated employee retention tax credit. That amount was done in order to combat, announcement was made to combat these numerous employee retention credit claims made by these self-proclaimed experts for businesses to claim credits that they really weren't eligible for. So eligible businesses have until March 22, 2024, so not a whole lot of time, a couple of months, to file for this voluntary disclosure program with the IRS. Now, the exciting part of this, if there is anything exciting about tax, but for me, everything about tax is exciting, is that the IRS recognizes is that because many of these employee retention credit experts charged a percentage fee based on the percent of the credit, like in the agreements that I've seen, usually it's 13 to 15%, that the businesses really never received the full amount of the refund that these promoters had them apply for. So the exciting part here is that taxpayers accepted into the program will be required to repay only 80% of the full amount of the credit that they received. In addition, the business won't have to pay back any interest that the IRS paid to the taxpayer on the employee retention credit claim. Now, businesses that are unable to repay the full 80% amount may be considered for an installment agreement, but they'd be required to pay penalties and interest in connection with entering into an installment agreement with this voluntary disclosure program. So to qualify for the program, the business must have provided the IRS with the names and addresses Nothing's free here. Telephone numbers of the advisors that they use to prepare this employee retention credit application. So the IRS is very interested in finding out who these promoters are and dealing with them directly through, I guess, both civil and criminal vehicles that they have at their disposals. Now, businesses, tax exempt organizations, and government entities that meet the following requirements are eligible to apply for the voluntary disclosure program. So I'll run through this list quickly. The employer retention credit claimed on an employment tax return, which is where that occurs, has been processed and paid as a refund. It has been cashed, deposited, or applied as a credit to other tax. The applicant believes that they're not entitled to the amount of the employee retention credit. The applicant is not under an IRS employment tax audit or a criminal investigation by the IRS, and the applicant has not had its employee retention credit claim reversed or received notice of the IRS's intent to reverse its employee retention credit claim. Now, to apply for the program, eligible businesses can apply by submitting IRS Form 15434. It's called the Application for Employee Retention Credit Voluntary Disclosure Program. No surprise there. If the application includes periods in 2020, the Special Employee Retention Credit Voluntary Disclosure Schedule Form SS-10 consent to extend the statute of limitations needs to be applied because, as I mentioned earlier, we're bumping up against April 15th, 2024 for 2020 employer retention credit claims. So also that any businesses that claim the credit through a third-party payer, payroll provider under the provider's employee ID number may participate in the program as well. But the application in the Form 15434 must be done through the third-party payer on behalf of the individual employer. Now, as mentioned earlier, applicants unable to pay the full 80% may be able to enter into an installment agreement with the IRS by filing an IRS Form 433B, a collection information statement for businesses to submit with their employee retention credit Form 15434 application. So a few thoughts here. It's important to note that the voluntary disclosure program is only available to those businesses that have actually had their employee retention credits processed and paid, cash that check, or taken a credit for those funds. Businesses with pending employee retention credit claims that they filed but haven't gotten refunded yet may request withdrawal from the employee retention credit program under the IRS's special withdrawal process, but that's a different program than what we're talking about here today. And finally, as a framework, announcement on January 16th by the Senate Finance Committee and also addressed by the House Ways and Means Committee is that there's a move afoot to repeal further employee retention credit claims as of January 31st, 2024. Previously, we had mentioned that employee retention credit claims could be made until April 15th, 2024 for 2020 and through April 15th, 2025 for quarters in 2021. So whether a business has received a refund, has a claim that they may be questionable, or has what they believe to be a valid employee retention credit claim that they have not yet filed application for, the time to act is now. So that's all I have on this topic. I know it's a lot to run through quickly. If there are any questions, please feel free to reach out.
Frank, thank you very much for that update. And as you point out, it is a complicated topic. There are lots of employers wondering, I'm confident, did I get it right? Should we be looking at doing anything to make adjustments on or before April 15th? Please trust that the bond team can be helpful. Frank and others certainly would be delighted to hear from you if you have questions you want to bring to us offline. With that, let me turn to our final speaker for the afternoon, and thank you again, Frank. We have Allison Roach with us from Buffalo. And Allison is going to be speaking about defending borrower defense claims, which is a tricky issue for our institutions of higher education, many of whom we know are, or which I should say, are tuning in as we are live here. And of course, a big part of the client portfolio that Bond proudly serves. So Allison, we'd love to hear about what you're learning and otherwise what might be applicable to our institutions of higher education assembled here and others just wishing to understand this issue better. Please, Allison, the floor is yours and welcome back.
Thanks, Gabe. So as some of you might recall, my colleague Seth Gilbertson spoke on this topic in August of 2023. But we thought it made sense for me to come back and talk about it some more because since August 2023, attorneys at Bond have drafted and submitted well over 100 borrower defense responses for various institutions of higher education across the country. So as a result, we now have a much better sense of the Department of Education's criteria, and we also want to encourage institutions of higher education who receive borrower defense claims to initiate the process of responding to these claims as soon as possible. So for those of you who attended the August 2022 webinar, some of my presentation might be a bit of a refresher, but I do think it's important to provide context for those who are not caught up. Next slide, please. Okay, so very briefly, what are borrower defense claims? So it's really just a federal regulatory scheme that protects students if there's some kind of fraud or misrepresentation. So for instance, or if there's some kind of fraud or misrepresentation that might induce a student to enroll in an institution of higher education. So for instance, a student could argue, look, this school induced me to enroll by guaranteeing that I would have great job offers after graduating from the school. And then I graduated from the school and I didn't have any job offers and I was unemployed. So I shouldn't have to pay back this loan. I'll say that it's usually not, these claims are usually not this straightforward or obvious. There are multiple grounds on which former students can claim that the school made various misrepresentations to them, and some of them can be pretty frivolous, can seem very frivolous on their face. But so basically the Department of Education will then look at these applications and determine if there was a misrepresentation. And if they do determine there's a misrepresentation, the Department of Education will relieve the loans. And then the Department of Education may go to the institution found responsible for the misrepresentation and try to recoup those funds, which can be enormous sums of money given how large student loans can be. So this mechanism has been around for a while, but until recently, it didn't really affect mainstream public or private institutions. Next slide, please. So Seth talked at greater length in August about the regulatory context and how we got here. But basically, we have some new regulatory changes that went into effect on July 1st, 2023. So the goal here for the federal government was to expand the eligibility, remove barriers, and provide for automatic discharges in some cases. And so these claims can be brought by individual students or by groups of students. And ultimately, borrowers with approved claims will receive full relief. And as discussed earlier, the regulations can allow for the recoupment from the institution, and they place the burden of persuasion on the institution once the Department of Education has made factual determinations. Next slide, please. So why should you respond? So there has likely been some confusion because the Department of Education tells institutions that they may respond. However, we encourage our clients to respond and to respond aggressively. So if you take nothing else away from this presentation, please take away this. Respond to any and all borrower defense applications that you receive. And so the reasons behind this, there are several reasons, but as discussed, the consequences of an adverse finding are potentially severe in that the Department of Education may attempt to recoup the money from the school. But also the evaluation process and the criteria used by the Department of Education are pretty opaque. So we really want to provide a robust defense and provide as much evidence from the institution as possible. And additionally, we send over a list of affirmative defenses, which allow our clients to preserve legal defenses down the road if this, proceeds beyond the initial response. And I think most importantly, if an institution does not respond, the Department of Education may even presume that the institution does not contest the claim. So it's just very, very important that institutions do respond once they receive a borrower defense claim. Next slide, please. Okay, so how should institutions prepare even if they haven't received a claim, what should they be doing? So first, it's really important to determine who will be responsible at the school for responding to these applications. And whether that's internally or externally, schools should engage some sort of legal counsel in this process as soon as possible. Once we're engaged, our process is typically to briefly review the claims raised in each borrower defense application, and then we'll send information and document requests to the school in order to refute that would refute the borrower's claims. So we recommend that schools designate a point person from the institution who is in charge of tracking the various claims and, most importantly, coordinating the document collection and information gathering. Appointing an internal point person significantly expedites the process of responding because people typically within the school tend to have a better sense of which departments will have necessary information to refute the borrower's claims, whether that be coordinating with financial aid or career services or various academic departments. And in our experience, it often takes more time than expected to collect and organize these documents. What with everyone's busy schedules, it's often not the top priority. So really, the sooner that schools can engage counsel and designate an internal point person, the better. And then once we've gathered the necessary information, we investigate the borrower's claims. So it's very important not to take borrowers' claims at face value. So for example, we've had some instances where borrowers will present a litany of grievances against the school, and then we later learn that they've only attended the school for a single semester and never graduated. Similarly, we've had borrowers claim that the school's career services office misled them and it harmed their career prospects, but then we do a quick Google search and we find the borrower's LinkedIn, and we learned the borrower has been gainfully employed in their field of study since graduating from the school. So basically, it's very important to investigate and verify the claims. Even if the borrower makes slight misrepresentations, we do want to call out those errors and present supporting documentation and attack their credibility as much as we can. Next slide, please. So practically, how exactly are we responding to these applications? So this is kind of an outline of what we're currently working on, but first we have this component of refuting the facts presented by the borrower, because we want to make sure that we highlight the facts and supporting documents and just get that in front of the Department of Education as they're evaluating the borrower's claims. But we also make legal arguments and raise defenses based on the information that we've collected or information that the borrower has provided. So for instance, if the borrower checks a box indicating that there's no financial harm or that they didn't rely on the school's alleged misrepresentation, we can say, see, the borrower themselves admits there wasn't any financial harm or that they never detrimentally relied on the alleged misrepresentation. And then we also often address the actual damages and then review documentation from the school to determine whether tuition and fees were less than the loan or whether any of that loan was given back to the borrower for living expenses, so that in that way we can argue, the school is not responsible for the money that did not go to fees and tuition. And then finally, we put in some boilerplate arguments and affirmative defenses like statutes of limitation or lack of due process, just to preserve our ability to raise these arguments and defenses down the road if we end up in any further regulatory proceedings, litigation, or appeals. Next slide, please. So finally, this is just a quick summary of what we recommend moving forward for institutions of higher education. Definitely, as we discussed, very important to designate an internal point person who will be responsible for coordinating and just organizing the institution's response to the borrower defense applications. we really recommend engaging legal counsel, even preemptively. You don't necessarily need a lawyer, but we really encourage you to have one, mostly because the legal defenses raised are probably best raised by trained attorneys, and because getting this right early in the process is important and also more economical for businesses. And if this goes to the next step, like a recoupment proceeding or an appeal, it's really important to have counsel with experience in this area to help you respond effectively. So just stay organized and track all borrower claims. There are often a few waves of claims that come out, so it's just really important to stay organized, collect documents, and investigate as soon as possible. And then finally, draft and submit borrower defense responses. After that, we watch and wait. Some of these timelines related to borrower defense go out into 2026, so it's uncharted territory. There's a lot of litigation and rulemaking going on in this space right now, and we will continue to keep you all updated on the latest developments in this area. So if you receive any borrower defense notifications, please feel free to reach out to me, Seth Gilbertson, any of the attorneys in the higher ed practice, or any bond attorney with whom you are regularly in contact with. Thanks, and back to you, Gabe.
Thank you. And so as I wrap up here, first, Allison, let me thank you for that very informative presentation on borrower defense claims and the importance of moving quickly and leaving nothing to chance. Certainly, as you point out, we have a number of attorneys at the firm who can be helpful if that's of value to any of those tuning in here. Let me switch to making sure that all of you are aware of something forthcoming, webinar specifically that the bond team will be hosting. It's the third in a series that we have put forth with the New York State Office of the Medicaid Inspector General. And in our next program, we're going to be looking at training standards and effective lines of communication under Medicaid compliance programming. For those of you who are interested and otherwise wish to learn more, it's on the 31st at noon Eastern. You can email me directly and I'll point you to where it is that you sign up, and we look forward to having you. I also want to just make sure that everyone is reminded that Kristen Smith will be with you a week from today, and she will be addressing the budget with a labor and employment lens, and there will be other speakers, of course, accompanying her. I will be back in early February for my next opportunity to be with you. I very much look forward to that. And then meanwhile, wishing everyone a terrific afternoon. Thank you so much for tuning in.